Thank you very much, Cory and Gonzalo. You were too kind with your presentation. We hope that we will meet your expectations and most of all the expectations of our participants. I would like now to ask my colleague Vitoria to share our presentation, and I will then make a quick overview of the agenda of what we are going to talk about today. So we'll quickly do a presentation, a general overview of what trade secrets are, what their importance is, and the importance also of preventing trade secrets theft. This part will be covered by my colleague Vitoria, and then I will say a few words about the legal framework of protecting trade secrets in the European Union. I will present also the findings of a study that the EUIPO published last year, and then I will pass the floor back to Vitoria to present two cases. And then in the end, based on our experience, based on the findings of the study that I just mentioned, we will share with you some best practices which you may find useful in your daily work. So I will now pass the floor back to Vitoria for her general overview on trade secrets. Vitoria, over to you.
Thank you, Plamen. Thank you, everyone. Good morning and good afternoon. So moving forward, I'll give a brief introduction of trade secrets. So the trade secret, as already mentioned, is a valuable piece of information for an enterprise that is treated as confidential and that gives that enterprise a competitive advantage. Here's a general understanding of the requirements. For an information to be considered as a trade secret, it has to be commercially valuable because it is a secret, known only to a limited group of persons, and subject to reasonable steps taken to keep it as a secret. Here, the images show some examples. So we have the Google algorithm, KFC's recipe, the Coca-Cola recipe. I think this one is the most well-known trade secret. Then trade secrets can be divided in both technical and commercial secrets. Technical will refer to technical information. So, for example, manufacturing processes, technical drawings, designs, prototypes, while commercial secrets are more related to the business itself. So, customer and supplier information, business strategies, client lists, information about employees or their teams, etc. The importance of trade secrets. Trade secrets are super important because they encourage innovation, they create value through labor and effort, they support the commercial ethics and roles, they are cheaper than protecting patents. Their protection lasts indefinitely or until it's not a secret anymore. There are no registration costs and there is immediate effect of protection. However, there are also negative effects of it. So the first one is that it does not provide the exclusive right. Only patents and utility models will provide this sort of protection. They may be patented by someone else who developed the relevant information by legitimate means. Once made public, it will be available to everyone, so it will not be a secret anymore, and then it will lose its value. They are more difficult to enforce due to its secrecy nature, and they are also more difficult to license or sell also due to its secret nature. Now, trade secrets are especially and particularly important to SMEs, and that is because they provide competitive edge, protection at a minimal cost, long-term protection. It is an asset and it also provides agility. So SMEs are often known for having limited resources to spend in IP protection. And so trade secrets offer protection at a minimal cost, ideally for a long term. And actually, there was a joint study by the EUIPO and the EPO that found out that IP rights are a significant factor in the success of European startups. So European European startups that invest in IP rights are 10.2 times more likely to successfully secure funding. Then moving to trade secrets theft. Trade secrets theft is the illegal asset or acquisition of information that qualifies as a trade secret. This can be, for example, a result of unlawful acquisition, cyber espionage, fraud, and others. Some of the impacts of trade secrets theft will include loss of customer, loss of investment in research and development, negative impact on innovation, reputational damages, negative impact on the business worth, and this is stimulated by lack of awareness. People are usually not that aware of risks of having their trade secrets leaked or how to protect them, wider online exposure of companies, slow-paced policymakers to make the regulation more uniform, increased globalization of markets, and development of new technologies. And just for your information, the European Commission adopted a new recommendation on the combat of counterfeit online and offline, and this includes a cyber theft prevention toolkit. This cyber theft prevention toolkit will be explained by the European Commission in a workshop that's scheduled for April 24th. So we left the registration link here. We can also share with you later so that you can register and learn more about it. Now I pass the floor again to my colleague Plamen, who will explain a bit more of the legal framework.
Thank you very much, Victoria, for this nice general overview. I will now proceed with sharing some details about our trade secrets protection practice in Europe. The obligation for the European Union to protect trade secrets stems without any surprise from Article 39 of the TRIPS agreement. You know, or you can see on the screen the definition provided there. And what would be interesting for you to know is that the European Directive on Trade Secrets actually mirrors the definition of trade secrets provided in the TRIPS agreement. So it is pretty much the same. You can see the definition provided in Article 2.1 of the directive. And here on this slide, we highlighted some of the legal principles that are raising questions, problems in practice, and to which various European courts have provided interpretation and made them clear. We already have this guiding, and later on in the presentation, I will focus on these guidings provided by the courts. So once again, to facilitate the further understanding of what we are going to talk about later on, just quickly to remind you that also in Europe, what qualifies as a trade secret is a piece of information that is kept secret, that has commercial value because of this, and that has been subjected to reasonable steps to remain secret. The directive on trade secrets provides also for protection measures. According to the directive and the provisions of national laws, the holder of the trade secrets has the right to request from the court a cessation or prohibition of the use or disclosure of the trade secrets, and also to prohibit the production, offering, or placing on the market of infringing goods. There are also corrective measures foreseen by the directive, such as the recall or destruction of the infringing goods, and of course also competent authorities on the request of the right holders can seize the infringing goods. I already mentioned that the European Union Intellectual Property Office published in summer of 2023 a study that was supposed to identify any litigation trends related to trade secrets. The study has three parts, and the first part is investigating quantitative trends. meaning basically how many trade secrets cases have been dealt with by the European courts, and findings in terms of numbers, but numbers that are important, and I will give you a few examples later on. And then the second part concentrates on the qualitative analysis of trade secrets litigation trends. And finally, in this study, there is a significant case law collection, summaries of relevant European case law that is particularly useful for practitioners. You have the link to the study in the presentation in case you are interested to get into the details and the findings of this study. I encourage you to read the study. Some of the quantitative trends, for instance, the study finds out, probably contrary to what you may know about trade secrets, that the most litigated cases of trade secrets concern downstream commercial information. Not necessarily technical information, which we know is alternatively protected by trade secrets. And what we know from the 101 IP books, where trade secrets are often presented as an alternative to patent protection, what we see actually in the real life, at least in the European practice, is that downstream commercial info, namely price lists, customers lists, distribution methods, marketing data, are the subject of trade secrets mainly litigated in the EU. Another information in terms of quantity that you may find in the study concerns the claimant and the defendant profile, but you will find graphics like this one that concern, for instance, also the success rate of certain claims, the most common raised defenses in litigation cases, and further interesting information that may help you define your strategy when you go to litigation, either as a claimant or as a defendant. But today we will mainly focus on the qualitative trends and see how the European courts interpret certain legal concepts that are relevant for trade secrets. Now, we have seen the definition, but in this definition there are certain criteria that have to be met, and they are not necessarily presented in detail in the directive. So what was necessary was for the courts to give interpretation to these concepts. And you know probably that in the European Union, we have our Supreme Court, so to say, the European Court of Justice, but so far we don't have a guidance from the European Court of Justice. What we do have is instead many decisions of the national courts, and later on in the presentation you will hear me often referring to decisions of the German courts, of the Estonian courts, of the Austrian and the Italian courts. So just keep this in mind. So again, what we are going to talk about are the three main requirements for a piece of information to be considered a trade secret. The first one is, of course, the secret. What makes a piece of information secret? One of the important findings of the courts is that it's not just the kind of information, but it is also the precise configuration that is important for a piece of information to be considered a trade secret, because the different elements might still be, the different components might still be in the public domain. But what is important is the way this information is organized, the way this information is processed, the way this information is extracted, or certain criteria are extracted from this body of information. Another important finding with regard to the assessment of a trade secret is a finding of the Court of Brussels in a decision from 2022, which indicates how the assessment of this information has to be done. And the court said that it has to be done from the perspective of the average person in the sector, not necessarily from the perspective of a former employee. There is another guiding given by the Düsseldorf Regional Court, which stated in a decision that the requirement of the information being secret would be satisfied when individual components of the information may be obtained via reverse engineering, but not in their precise configuration. Another important guiding for us given by the courts. Now, you saw also in the definition the concept of readily accessible information, which does not necessarily mean that it has to be directly or immediately accessible, but still some degree of effort is still needed, like for instance in reverse engineering. When deciding on whether this effort is sufficient or not, one has to consider the expenditure of time or resources necessarily for a third party to obtain the information independently. In the particular case of the Austrian Supreme Court, the court found that working hours, up to 25 working hours in order to recreate an architectural or a design plan are not necessarily sufficient to consider this a secret, to consider this piece of information to be a trade secret. Now, the other important concept clarified by the courts is the concept of the persons within the circles. Obviously, employees honestly acquired experience and skills are justifiable, and it cannot be considered as a person within the circles. Now, there are here some issues that the courts encountered in terms of possible double standard when you litigate against a former employee and when you litigate against a competitor of yours. But I'm not going into these details now. Instead, I would refer to a finding of Estonian Supreme Court that found out that employment contracts defining trade secrets too broadly cannot be construed as limiting the use of long-standing knowledge and experience acquired during the employment. This again refers to what you see above, that trade secrets protection is excluded when this information became known to a former employee due to his honestly acquired experience and skills. This is a very important exception, and this is also a defense often raised in litigation cases. Now, when we talk about the commercial value, the most important characteristic here is that there should be a causal link between the secrecy and the commercial value. Furthermore, the recital 14 of the preamble of the Directive on Trade Secrets says that the value, the commercial value, does not necessarily to be present, to be actual. It may even be potential, and it still justifies the commercial value of the information kept secret by the trade secrets holder. It can also exist where the unlawful use would harm the interests of the information holder. So basically, there are two tests here when we speak about commercial value and when the courts are trying to find out whether this piece of information actually has a commercial value. First of all, it has to have a value for the trade secrets holder himself. And the second test would be whether the unlawful disclosure, acquisition, or use of this piece information is actually causing harm, financial, reputational, moral harm to the trade secrets owner. Now, in a decision of the Tribunal of Milan, another important aspect of commercial value has been clarified. namely that the assessment should be made not only in relation to the information itself, but also to the method by which the information is processed. It was a case concerning information processed by artificial intelligence tool, and then the finding was that this is also very important. This is something that adds to the commercial value of a piece of information. Now going to the third important requirement for a piece of information to be kept secret, the reasonable steps. What is important for you to take from this presentation is that it is not set in stone. This is a very flexible requirement that depends pretty much on the specifics of each particular case. So the courts basically need to decide on a case-by-case basis, taking into account the importance of the information for the trade secrets holder, the size of the company, and other factors that you will see well ordered by the German court on the next slide. But the trend is that the interpretation is case specific and the standard is rather flexible. This is what is important here. The Tribunal of Milan, in another decision from 2022, consider that the assessment must take into account both the physical and the cybersecurity measures that the trade secrets holder undertook in order to protect his information, and they have to be put in a specific context, not just in the abstract, but they have to be specifically tailored to the type of information that is protected. At the same time, the court did not raise the bar, the standard of protection too high. It found out that more than minimal protection would still be sufficient. And now I would like to present to you this decision of the Düsseldorf court, which created a list of factors that need to be considered when a decision is taken on whether the trade secrets holder took reasonable steps. And then they have to be weighed out. A fair balance needs to be found in order to conclude on whether reasonable steps have been taken. The type of trade secrets needs to be taken into consideration, the specific circumstances of use, the value of the trade secret, the nature of the information, how important is this piece of information for the company. It may be crucial. The size of the company, as I mentioned already, the usual confidentiality measures in the company, the type of labeling of the information, and the contractual provisions foreseen in the contracts between the employer and the employees. This is a very important list of requirements, so you may want to note it. And you may use this also in your cases, in your defense. Another trend that the study identified is that very general steps, too broad non-disclosure agreements, basically saying you have to keep any information that you got in touch with as a trade secrets. This is not sufficient. These provisions needs to be more specific, and this has been stated by several courts and administrative authorities throughout the European Union. What is also important is that persons needs to be informed. They need to be made aware of the intention of the trade secrets holder to keep this information secret. So in order to sum up, to summarize what we just discussed, very important findings of the study. With regard to the definition of the trade secrets, is that a coherent definition is a key starting point for the harmonization of trade secrets law within the EU. You know that we have various member states, but this directive contributed to a high level of harmonization already. And whether a piece of information is a trade secret or no remains a key issue in trade secrets litigation. This is the most common defense, as I might have mentioned earlier, in litigation cases. When you are brought to court for the unlawful acquisition, disclosure, or use of trade secret, then the first defense you would raise is to say, yes, but this information is actually not a trade secret. Then another key finding of the study is that what you claim to be a trade secret, this piece of information needs to be well defined. It needs to be precisely identified. You cannot just say any information is trade secrets. And for undisclosed information to be protected, of course, what we just mentioned, proper protection measures needs to be taken so that this information remains secret and is not easily acquired by any third party. And then there are the measures that we also mentioned in the beginning, and they should not be understood in isolation, but rather in their entirety. You may use different measures to protect your trade secrets, and it's better for you to use them together and ensure the balance between the protection of the interest of the trade secrets holders and the other policy goals of the directive. A piece of practical advice for those of you that are in the private practice, but also for students. Again, to summarize, the issue identified by the study was that often trade secrets are not sufficiently specified, which later on in litigation cases increases the chances of you to lose the case, because again, the case will be dismissed because the object of protection was not clearly defined by the complainant. The challenge that we see in the litigation cases is that stakeholders fear that, on the other hand, if they make the claim super specific, this will disclose their trade secrets, because if you start describing it in detail, of course, then you are revealing the substance of the trade secrets, and then you can lose protection. But this is why the directive, the European Directive on Trade Secrets, foresees also certain measures to keep the secrecy of the information during the court proceedings. And this was the last conclusion, a practical tip that I wanted to give you. And I will now pass the floor back to Vitoria to present two cases in detail.
Thank you, Plamen. So before moving to the detailed case studies, now we have it. I think it's important to approach the confidentiality issue. And this is just to say that anyone involved in a legal case about trade secrets, and this includes lawyers, court officials, witnesses, judges, etc., cannot use or disclose a trade secret if the judge has ruled it confidential, even after the procedure is ended, and for obvious reasons that the trade secret value relies on its secrecy. There are, however, two exceptions. The first one being if the court decides that the information wasn't actually a secret, or if this information becomes eventually publicly known. So now moving forward to litigation cases. The first one is from Finland. So what happened is that Superscale created a commercial script for a mobile game called Traplight's Battle Legend. This commercial script can be protected by copyright, but also has some elements that are protected by trade secrets. So Superscale and Traplight entered into a group partnership agreement, and Traplight ended the agreement. But the moment that Traplight ended the agreement is important in this case because it was before the parties agreed on royalties, distribution, and payments for this commercial script. So Superscale claimed that Traplight had acted contrary to good business practices and faith, and that it wrongfully exploited its trade secrets by seeking to exploit the commercial script without paying the proper remuneration. So here, the court had two findings. The first one being when they analyzed the agreement that the definition of intellectual property did include trade secrets, but did not include commercial script in the definition of intellectual property. So basically, the court understood that the definition of trade secrets in the agreement was restrict, that is, would not imply that commercial scripts was under the definition of trade secrets and intellectual property. And also, they understood that Traplight was actually hired for a commercial assistant more in the uh, more for the recommendation side and not to exploit the commercial script directly. So Superscale ended up not having the rights over its commercial script. Then moving to the French case, what happened here was that an employee in the marketing department of the Paris airport developed in her spare time an interactive station enabling travelers to access some services that the airport was not able yet to provide. The employee declared that it worked on it while it was not in the course of her employment. And then 1 year later, in 2007, the Paris airport communicated the development of interactive stations to their clients. So the employee went to court to claim for damages and compensation on the grounds of unfair competition and detriment of her image. So the findings here were the court first found that the method developed by the employee could not qualify as protectable know how since it did not meet the requirement of secrecy. And eventually, it was possible to state that the interactive station created by the employee was more advanced than further versions developed. However, it was not sufficient to conclude that there was economic value in the idea, and the employee's appeal was therefore rejected. This case is important to illustrate the steps that anyone should go through when trying to claim a trade secret protection or know-how. So moving forward, here are also some well-known cases in the UK. They are mainly here to show that the discussion of trade secrets is really ancient and that the first one, Facenda Chicken versus Fowler, uh, establishes mainly that obligations are stricter during the employment than after the employment ends, because during the employment, there are the implied terms of good faith and fidelity, and after the employment, the fidelity disappears, but the good faith remains. Ben's Brewery versus Hogan also says that you should not disclose confidential information to unauthorized recipients. Meriwether versus Moore says that you do not copy or deliberately memorize confidential information for use post employment. And Saunders versus Pearly determines that you must actively promote your employer's best interest. So now, giving the floor back to Plamen for best practices.
Thank you very much, Vitoria. Yes, we had this last list of cases depending on how your jurisdiction is influenced either by the common law or by the continental law. You may find those interesting. So in case you want to go back and check more details, feel free to do so. So In order to make a general conclusion, again, in practical terms, we told that we will share the best practices when it's about protecting trade secrets. So the first most important conclusion and the first question that we usually receive is, what is the best way to protect trade secrets? The answer is, it depends on the type of the information that you want to protect, but in 99% of the cases, it will be always a combination of legal and technical measures. A bit more into the details, you need to secure appropriate access protections, be it physical or virtual, online, etc. Then you need to train your employees to explain to them what a trade secret is, how do they have to behave in order to prevent disclosure or unauthorized use. Entire policies for your company you may want to implement in this regard. And then, of course, you need, once they're implemented, you need to constantly monitor and improve them. Calling a lawyer is always a good idea. I'm not going to talk about this. More on the legal side, you have to foresee confidentiality agreements, make sure that they are specific, non-disclosure agreements, to create a paper trail and oral agreements reinforcing the confidentiality may also help. Create a confidentiality relationship with your business partners. This also helps. And you may also provide non-solicitation clauses in your agreement so that when employees leave your company, they do not disclose or make any unfair use of the trade secrets they may know from your company. More on the enforcement side, again, putting the focus on practicalities. Before going to the court, before litigating cases, try to answer those questions to yourself. Whether there was actually a signed contract between you and your employee. Does this contract contain the confidentiality provisions? Can you enforce this contract based on what is foreseen in it or based on the legislation in your country? Does this contract tackle the prohibition to share information or knowledge outside of the company? And whether are you lawfully allowed to monitor what the employees are doing, because if not, then you may get into trouble. You need to pay close attention also to, in order to strike the right balance, because this is the exercise that the court will do, to think about the data protection clauses, some fundamental rights, various regulations touching upon trade secrets as well, and anything else that may impact trade secrets or your rights to seek protection before the courts. What is also important for you to remember, in case you decide to litigate or in case you have to defend yourself in a litigation case, all these exceptions you can raise as defenses before the court, that there is no trade secret misappropriation if a trade secret has been an independent creation. Trade secrets does not protect you against that, unlike patents. You have to make sure that the information that you think is trade secret is not already in the public domain, because then it's not a trade secret anymore. And you have to pay attention also to the fact whether the other party did not take proper efforts to keep the information secret, or if you did not take the proper measures to keep this information secrets. Again, All these are arguments and defenses that you can use in litigation cases. This is where most of the plaintiff claims fail and most of the defendants succeed. So I think, bearing in mind the late start, we managed to catch up a bit with the time. We'll be happy to answer your questions. Up to the moderator now to decide whether to allow time for questions now or maybe at the end of the presentation, but I will be here and will be happy to answer your questions. Thank you very much. Corey, back to you now.
Thank you very much, Vitoria and Plamen. We have time for for a couple of questions. First question is it possible to put a tangible value to trade secrets owned by a company? And how can this be done? How can you put a value to the trade secret, for example, of a publicly listed company? So this is actually a series of questions. And then can the value of a trade secret be inferred, or can it be can it be checked against the annual published financial report of the company?
Okay, let me take this one. I understand that both questions relate to the value of trade secrets, right?
Yes.
How can it be proven or how can it be evaluated? Well, an example would be, for instance, by estimating the amount of working time needed to independently acquire the information. This would be one way. Then, of course, it is also a bit subjective because what can be important for your company may not necessarily be so important in general. Another way of evaluating your trade secrets would be in case of misappropriation, the damage caused to the company, the lost profit, the profit that you otherwise would make if the trade secret was not disclosed, the harm suffered by you, including moral prejudice. Of course, this will be something determined by the court in case it goes to court. As far as to the balance sheets, how this can be reflected there, I'm not so much on the accounting side, honestly, and it would depend on each particular legislation or the particular provisions. But I can give you an example. For instance, in some jurisdictions in Europe, you can have tax deductions on certain trade secrets that were developed, for instance, during research and development project. So I believe the accountants, the colleagues that are dealing with accounting, they have their ways to evaluate the trade secrets.
Thank you very much, Plamen. Maybe we can have I can read one more question. Maybe Victoria can answer the question. What is the best and safest way to guard a trade secret?
I can start answering and then I pass the floor to Plamen, but thank you for the question. There are some, and it will depend also in the structure of your business, but of course, confidentiality agreements, as Plamen said, entering these agreements with your employees and making sure that they need to maintain this information as confidential while they are working and after, making sure, for example, that inside of your company you have robust systems and data protections schemes that will make this information be more effectively protected. another thing is limited access. Not everyone has this, but this is really efficient. You only limit some sort of folder or information to those who really need to have access to it. Some systems and some companies leave it completely open to every employee to access it, and it may not be the best way to tackle it. Plamen, do you have something to add?
Yes, the most important answer here would be that the best way to protect your trade secrets would be to put in place a combination of legal and technical measures. That's the main conclusion. And then from there, depending on the particularities of the information, of course, you need to find the most appropriate measures. If this information is kept on a piece of paper, find a big and very good safe. If it's kept in an online environment, which is mainly the case nowadays, then you have to put into place online security measures, all kind of electronic protection, cyber protection, and then the legal measures, we talked about them already. But again, they would depend in particular on your company's setting, on the number of employees, on what they are dealing with. The advice is make it specific. Make it specific, taking into account what this particular employee is doing, what kind of information he is dealing with. Don't just put some general standard, very broad and very common provision, because this will not help you later on if it comes to litigation.